Hi everyone, thanks for logging in this morning. We appreciate we've put something together on pretty short notice, and we've decided to speak this morning just as an opportunity to try and I guess offer some help to the industry around what's been happening with this dramatic snap lockdown for the construction industry in Sydney. So over the course of the weekend, our team at Morrissey Law, we've been looking into some of the things that are happening, pulling upon our information resources from when COVID happened last year, albeit this time around what's happened to the construction industry is far more dramatic. And we've tried to put together some resources this morning to be able to help you and your business. So I'm speaking this morning with Aaron Bolton. Hi, Aaron.
Okay.
So Aaron's one of our senior lawyers, and I've asked him to speak with me as well because this time last year, Aaron wasn't with the Morrissey team, but he was in-house working with a large contractor, so has hands-on experience around what problems businesses are facing when quick decisions are being made around COVID and what lockdowns could be. So I guess just to set a bit of tone and context, we're working through things as we understand it at 10 a.m. on Monday morning. I wish I didn't have to be so particular about what that means, but things seem to be changing pretty dramatically. We're already hearing rumours about changes to the construction lockdown or shutdown, whichever way you want to frame it, starting to circulate. So we're just going to work off what we can see in front of us. We've pulled up the public health order. We've trawled back through the New South Wales Government sites. We've looked at the press releases. We've looked at the other material that's available to us. And we've tried to focus in on what people are raising with us as are the most critical things. Obviously, we prepared this on pretty short notice. Aaron and I were working through into it last night and this morning. And so please don't take this as legal advice. I know I don't want to have to throw a disclaimer out at the outset, but we're trying to cover, provide some information that's helpful in the context of the people that are coming along today. And just setting that context a bit further again, I know there's a lot of people working across all different parts of the construction sector logging in today, and we appreciate such a diverse and great attendance on something where we really didn't announce this till after 7 o'clock last night. But given we've sort of worked through the list, and most of the people that seem interested are on the contractor builder side, if I can frame it that way. So from mums and dads through to tier one. So we're going to be talking largely in the contractor context. I appreciate there's some people who come from a project management background or project management or consultancy background that are logging in. There's also some of our colleagues that are very senior and experienced construction lawyers as well. But what we're trying to do is put on our contractor hat and work through the things that they need to look at urgently. So quick run sheet. We're going to work through the public health order as we currently understand it. Again, I wish I didn't have to put those disclaimers around it, but there's already inconsistencies in the language that we haven't seen updated today. Looking at the critical claims, and I guess that's the big thing for us, what needs to be done right now. Aaron's going to touch on some insurance. We're going to talk about some of the gaps that have been raised with us over the weekend, and then we're going to touch into some Q&A. Now, on the Q&A, you can probably see one of the other panelists who is not on screen, just his name, Hamish Geddes. Hamish is one of the directors of Morrissey Law. He's going to be in the background working through the Q&A. So if you do have questions, please put them in. We'll do our best to answer it. I'm not going to make promises, but we will do our best to answer it. So I guess we'll just jump right in, Aaron. So I guess the first thing, we've sort of gone through the legislation or the public health order in some detail. I'm going to throw to you, Aaron. Did you want to work through the definitions, the first two slides, and what's covered?
Yeah, absolutely. So we've thankfully received in this order a definition of what a construction site is, and that's up on the screen there. This is really helpful because a lot of the queries we're getting at the moment are about whether or not what is a construction site. So as you can see there, it's a place of work, where excavation being carried out to erect, demolish, extend, or alter a building or structure. There's an exclusion in there for dwellings where persons residing, but that's also kind of bundled up a little bit later on in relation to the orders about not allowing people to do certain things in a home. There's what, thankfully again, some words around what is a retail premises, because some of the orders, as we know now, have carved out certain things to remain open.
Yeah, I think that's been important. So we're not going to work through the retail premises definition in any great detail, but particularly around building supplies and landscaping supplies, materials. We spoke to a number of manufacturers over the course of the weekend and suppliers, and even they are working in where that sits. But the retail premises provides the context around there. So jumping into the next one, just go forward. So this is the big one as it affects the construction industry, and I guess this is the most far-reaching order we've seen affecting construction in Australia so far. I mean, even Melbourne at its worst, construction activity was still going on in some respect. I'm going to read through the order. And I realised I didn't update something on my screen. I did in an earlier version of the slide and then obviously lost in the later. So I'll probably duck off screen for a second just to read that through to you. Excuse me. So the Minister directs that work is not to be carried out on a construction site in Greater Sydney unless the work is urgently required for the following purposes: to ensure the safety or security of the site, to deal with environmental risks, to maintain critical plant or equipment that would otherwise deteriorate. And now I'm just going to jump around for 1 second, and I'm sorry again, this is the pace in which things are happening more than my competence, I hope. But the language on that, if you go to newsouthwales.gov.au and go into COVID-19 around the rules for Greater Sydney, the language that is used on that website has already differed from what's provided in the public health order. So what it now says is to maintain and ensure the integrity of critical plant, equipment or assets, including partially completed works that would otherwise deteriorate. And I think we'll circle back onto that in a second, but that's a far broader definition already than what was originally provided. We've then got a D, to receive deliveries of supplies that would otherwise deteriorate, to maintain public utilities, to ensure the safe operation of existing transport infrastructure, by or on behalf of New South Wales Health in response to the COVID-19 pandemic or because of the emergency. And then further to that, the Minister directs an employee or other person is not to enter or remain on a construction site in Greater Sydney other than to carry out work required in sub-clause 1. I mean, it's a pretty hefty or pretty all-encompassing definition, isn't it, Aaron? Like we've really wiped out most things that are going on in the industry.
Yeah, that's right. It's the pickup of those additional words, as you mentioned, are quite critical. But yeah, obviously this has been drafted to be extremely broad, to cover pretty much anything that's going to go on. And that kind of catch-all there at the end in part 2 of 24AB, that no one is even to enter or remain on a construction site except for these things, really does put a shot across anything else that would could be argued to be carried on.
Yeah, so jumping into the next slide we've got, I guess we'll talk through these in a bit more detail. If we need to jump back and forth between the slides, again, I apologise. We put this together on pretty short notice. So I guess in the context of what's been raised, the big things that need to happen is you need to get onto your site and secure your site. As part of that process, you should be identifying and attending to any urgent work and identifying if you need to do something that falls outside of the lockdown. So, stage one, I suppose stage one, as far as we can describe it that way, is you need to work out what you need to do to secure the site, make it safe, and to ensure, to the extent that you're able to maintain the integrity of those works. Aaron, I guess coming from the in-house perspective, did you want to sort of share your thoughts on what might be involved around that?
Now, the list there is quite. I think the list is really good and really broad and covers a lot of the things that need to be considered. I think one of the issues that we've tossed around internally has been about the interpretation of these things, and I think everybody's working in such a dynamic environment, whether or not something is or could be done under the orders. I think there's probably going to be, a good argument for allow, today especially, to get these certain things done, where if perhaps they aren't going to be covered, but I think there'd be a strong argument around that.
Yeah, I think that's right, Aaron. At this moment in time, you need to get out there and do what you think you need to do. What follows on from this, I guess, as we work through this, is probably starting to put the systems and planning in place to work out what else needs to be done. Because I appreciate we're dealing with lots of different types of projects here. From, let's say, someone putting a deck on the back of a house, right through to those major infrastructure sites that are being delivered across Sydney. So it's got extraordinary breadth, and it's going to very much need to be dealt with on a project by project basis. So, that leads straight into the next one. You need to be talking to your employees, contractors, and subcontractors, both in terms of telling them that you're shutting down the site, you're securing the site, but also getting that information from them as to what else might need to be done. Particularly when you're at that business owner level, you might not be completely across what's there. The example, what materials are due to be delivered to site, what materials are there, what plant and equipment's there, what might need to be done to maintain some of those sites. You've got, we'll touch on this a bit later, but in addition to the language that's been provided in this order, and it's not perfectly clear language at the best of it. You're also going to have the obligation of the contract around, securing sites, maintaining sites, and minimising any harm or damage that's caused to those sites. So it's going to be a difficult process of meshing those two things in. You really need to get into that planning around potentially cancelling the order of materials, or seeing if they can be stored elsewhere safely. Obviously securing materials and equipment where appropriate, where possible, looking at off-site storage facilities and options. And then the big one we're probably going to work through today is working through the claims you may have or need to respond to. A lot of this is going to fall back to how you manage your communication systems and protocols. I suppose I should backtrack on something I didn't comment on at the start. We know there's some far-reaching implications of these latest orders around how people should work. We're going to cover that in a seminar or webinar later in the week. We're conscious, we're already almost 15 minutes into this. There's a lot of material. We're going to try and run a few different sessions over the course of the week. We've tried to target this at what's most critical. But stepping back for a second, you really need to be doing your planning around what those limited things are. So, environmental risk, safety, security, maintenance of plant equipment, avoiding the deterioration of sites. So using those, that reframed order or rules, depending on which version of the website you go to for New South Wales Government. And then obviously working out if your works otherwise fit into categories E through to H. Aaron, did you have any more thoughts or comments sort of rolling off the back of that?
No, I don't think so. We're getting a few questions come through. I think we'll probably answer them at the end, which I'll touch on.
Yeah, there are. Yeah, I think they're good. I'm just looking at the questions now, just quickly. I think we will touch on those at the end. Some we need to be. I'll be honest. We're putting our legal hat on here. Some of these things we need to trust you as industry. You're going to have a good understanding of what's involved in your site. My view at this moment in time is, take a common sense approach, like Aaron framed earlier. If you think something's going to deteriorate or be damaged or need some extra work to be secured, you're going to have to make that judgment call. And I think, it probably is allowable under the orders, but you really need to show why you've thought that and why you framed it that way. We were talking about that briefly this morning, Aaron.
Yeah, no, that's right. I think if you're going to do things like that today or maybe tomorrow, the best time, but if this order goes for 2 weeks, which it's currently the plan, you wouldn't want to be doing it in 2 weeks on Friday, because any kind of discretion that's going to be exercised is unlikely to be exercised in your favour at that point. I would imagine.
Yeah. One of the things I do want to emphasise before we roll into probably, dealing with the adversarial parts that'll roll off the back of the contracts is really getting those communication systems and protocols set up. That was one of the things that we saw, being lawyers, being advisors, as things that helped all parties when the last, or when COVID initially hit. Again, I appreciate it wasn't the depth of, depth of lockdown or shutdown that we're now experiencing, but I think, in terms of the test, they're having good communication systems set up with your employees, contractors, subcontractors, suppliers, between you, between all parties across the contract plane. So, the principal, superintendent, principal's rep, contractors, subcontractor, suppliers, it's just going to be critical. That's how you're going to also properly identify what needs to be done and how it fits within the ambit of these orders. Do you agree on it?
Yeah, I think that's probably correct. Yes.
Yeah. So the big questions that have already started coming through to us, and I guess this sets the context of what we're largely talking about today, is where should I be going to in my contract? And we got a good sense of that. Internally, we built out a pretty detailed map last year as to where to look. I'll throw it across to you, Aaron, because again, you're in-house and you were spending a lot of time talking about these. Some will work through in more detail, but it's critical that we look at each of these provisions, and it's going to vary contract to contract.
Yeah, that's the thing. There's many wonderful contracts of different types that everybody's operating under, so it's really hard to use a one-size-fits-all approach to this problem. We've got a whole list there of places you want to look, but I think what that really indicates is that the contract has to be viewed as a whole. It has to be interpreted and construed in that way. Some clauses, the first one we've got there is a COVID-19 clause. Some contracts have them, and that was, really off the back of different parties agitating and making sure that those were included in contracts. Since we got there April 2020, other parties, weren't really that concerned, and as a lot of us kind of felt that COVID was really, was going to kind of wind up, and construction especially would be safe and be able to continue. Unfortunately, that's obviously not the case now. So if there's no direct COVID-19 clauses, then we're looking at the other ones, the OTs, variations, looking at your payment clauses, the change in legislative provisions. That's actually a really interesting one, and something that probably is good to look at here is that's a very obvious clause to go to, but really check the wording there. The entitlements will vary under different contracts depending on what's the trigger for an entitlement. So really look at those ones carefully, no matter where you are in the contractual chain. Of course, suspension is how that's going to work. But really, I think instead of just one of the important things about which should jump out from the real variety of clauses that are listed here is that it's important to look at your contract as a whole and determine what the right path through it is for you. If there are a number of paths available, it's important to do that mental exercise and try and track through how you're going to be placed in the best position coming out of this in 2 weeks, hopefully, if not potentially longer, so that hopefully things can get going back on as quickly as possible. It's important, maybe don't jump at the first option. Make sure, I think, tracking through them all and at least for while you've got the time, perhaps today or tomorrow, is going to be critical.
Yeah, I think that's right, Aaron. The frustrating thing about these snap decisions, and again, we're not going to get into the politics of this whole thing, but a decision was made on Saturday over the course of the weekend. It's now affecting people on Monday. It's understanding what entitlements you have is going to be quite an arduous process. And even if you're a principal or superintendent, understanding what claims you need to respond to, how and why is going to be really important as well. So, we're going to talk through the COVID clauses in some detail. The change in legislation provisions was something that we, provided a lot of comfort to people and an opportunity for a lot of people to make claims and to do that in a way where it was a fault-free scenario, I suppose, in a lot of respects. The first time round, those provisions have started to change. I think sort of getting that communication right and getting the claim framed the right way right off the bat is going to be really important to, potentially obtaining that entitlement or getting the best outcome around that potential entitlement without being unnecessarily adversarial. We talk regularly about the contract is the tool for communication between the parties. That's why it's put together. It builds that framework around what people need to say to each other, what information they expect to get when they're communicating about these things. So it's important, particularly like Aaron said, to sort of work through it holistically and to understand what's going to be involved. For some people today, that might be a reasonably straightforward exercise. For example, if you're a residential builder, I know there's a few on today, and let's say you're working under an unamended HIA, MBA, or ABIC contract, they're the usual forms that we see in New South Wales. The pathway is going to be much the same on each of the projects, and you prepare one, you can replicate it for other ones, obviously looking into the particular circumstances of where that project's at, but the elements are the same. Unfortunately, for some of the larger contractors on here and commercial builders and particularly civil and infrastructure contractors, it's not going to be that simple. As lawyers, we're spending most of our days up to our eyeballs in looking at different contracts, and the approach taken around all these things is dramatically different. Obviously, we don't see the unamended Australian standards coming across our desk very often, or even the unamended GC suite. What we're seeing is pretty heavily amended, and we're seeing some pretty novel, if I can put it that way, pathways to deal with COVID. And what was a bit simpler last year in terms of most people could put the cap of it's been a change in legislation, it fits under that, we might be entitled to time and cost. It may not be as clear cut this time. And I think a bit of the approach that needs to be taken is to get the claims put out clearly and early, certainly within the frames that are provided by your contract, because not every principal and player is accommodating to those claims, particularly when they're not put on time and in the right form. And from last year's experience, I can say, hand on heart, that included some really difficult government clients. So while government is starting to put out some communication saying, look, they're going to approach claims with looking at the best outcomes for people, trying to be collaborative, work through these things. We understand everything's tough. That wasn't necessarily the behaviour we saw last time round, and obviously the shutdown is a lot broader than just the restrictions that we saw last time. Aaron, you were sort of living that a little bit last time as well, and it's the criticality of getting those claims on right in the right way at the right time is really what needs to be the focus for a lot of businesses over the next day or so to preserve the entitlements.
Yeah, I think you just don't want to be relying upon the good grace of somebody else in these circumstances when normally you can have a really good relationship with somebody, but when pressures come from different points, and unfortunately you don't want to be the person left who that's all you've got to rely upon. Not a nice situation to be in.
Yeah, particularly, I mean, this is going to cost money for people, and it really is going to be an argument about who's paying the cost of these 2 weeks and any follow-up that goes afterwards. When you're thinking about these claims, we'll touch on a little bit more, but there's, the impact might not be limited to 2 weeks, unfortunately. Jump in ahead. Just 1 second. So one of the big things we talk about is what the trigger looks like. There's a few different ways this is usually framed, often from the event. So let's say that was Saturday. From the awareness of the event, in this case, it probably was Saturday. The more curious one is when you could have or should have been aware. This is something that lawyers like to argue about, right, Aaron? That moment in time when awareness could have arisen. But I think, look, it's pretty reasonable to take the approach that you couldn't have been aware of this prior to Saturday. I think you can take the position, and again, not giving legal advice, but just trying to talk through it practically at the moment. It was pretty hard to guess that we were going to have an industry-wide shutdown despite whispers prior to Saturday, because we hadn't seen that before. What are your thoughts?
Yeah, well, we've kind of chatted about this one a little bit. I think this one is certainly arguable on both sides of the coin, and where that's the situation. You're just really setting the grounds for a dispute. And in these circumstances, avoiding disputes, I think, should be the number one goal. But where reasonable minds will differ, as in this case, you're gonna have both parties potentially fairly entrenched in their views on what is right, and that's going to be really, it's going to be quite partisan. So I think trying to take the sting out of that early on, I think would be really important.
Yeah, agree. So, I mean, the critical thing is obviously look at the triggers from contract to contract. I think we probably have a fairly unique moment in time where we can all identify a trigger come in pretty well at 11 a.m. or thereabouts on Saturday, even though the language didn't come out clearly until later that day. So the assumption needs to be the trigger's been oppressed. All those claims need to happen, and so you need to get them in ASAP. The big one I want people to be really conscious of is the ongoing notice obligations, and these are particularly relevant around time claims. They do exist around some variation clauses and some other provisions of the contract, but often now you see not only is there an initial notice of delay, there might be a subsequent one, and then ongoing notices until that delay comes to a close. So making sure you get those in, and even if the claim's knocked back, making sure that you continue to comply with the full the full breadth of what the clause requires is critical. We do occasionally see someone knocks back a claim and people put their hands in the air and go, okay, well, I won't do anything further. If you think there's a genuine entitlement there, follow the full claim process. And if that includes putting in ongoing notices every week or 2 weeks, or whatever the clause might require, please ensure you do so. The courts have pretty clearly found that missing one of those ongoing notices can be critical and kill your claim. So understand what you need to do and how to frame it. It's really important. And I appreciate, again, there's a mix of sophistication here. So I hope most of the lawyers that are on here are not in their heads in agreement with me. I'm sure I'll get some messages if they don't. But for people that are less familiar with these kind of processes, lean on your advisors. They might include, in-house lawyers. It might include some. I know some people work with us, but you might have other people that advise you, or other lawyers that, or claims consultants that are working with you, and get that advice. Understand exactly what needs to be done and how to get it on, because getting it wrong, might have some far-reaching implications at this point, and particularly if you're working on big projects. Like the dollar figures that are going to roll off the back of this 2-week window are going to be quite extraordinary in some events. So this is the one I wanted to focus in on. I'm going to throw straight across to Aaron, but the COVID-19 clauses did not exist, at least in March and potentially until early April last year. So we're in pretty new territory here, and this is going to be one of the first times we're really testing how they operate.
Yeah, that's right. I think this is, we touched on this before, and just as there are many different types of contract forms out there, there are going to be many different types of COVID clauses out there. Everybody, was kind of dealing with this on the hop at the time, and so what was drafted and went in place, at certain points in time is going to be, it's going to change and it's going to be different. So I guess, as lawyers always say, the first important thing is to read the contract, read the clause, and understand it in its entirety. And then it's a contract administration task there to make sure that whatever needs to be done is done as soon as possible. We've already kind of flagged the big question there and chatted about that. Could it have been reasonably anticipated? Michael and I both, and I think most lawyers would agree that both sides of that argument are going to have good arguments, whichever way you want to spin it.
But I mean, having that argument, get your best foot on, and I mean that sits on both sides, whether you're a contractor or a principal or principal's rep. There's arguments to be had that, Aaron, you and I were just debating about 8 a.m. this morning. That shows how interesting our lives are, but that's how we started our day, talking about, we've never seen this in Australia before. We have not seen the construction industry shut down. And again, excusing the politics and what, whether this is a good decision or not. Up until now, even Melbourne at its worst still had construction continuing in some capacity. But then you look at what's happened in other jurisdictions overseas, particularly when the Delta variant started to hit. There's been full shutdowns elsewhere. So what could you have reasonably anticipated? You're going to be able to mount that position as well as anyone, or get your lawyers to help based on what you knew and what factors you were taking into account when you signed that contract.
That's right. There's as lawyers, we all know that there are rules around contractual interpretation, and there are ways that contracts are going to be interpreted based upon the time the contract was entered into. So it's you're not going to be able to apply certain things that happened generally not going to be able to apply certain things that happened in the future. I think there's something in that for both parties to take away with, I would say.
Yeah, I think it's really important too to really, like Aaron just said, read the clause, read the contract. That is critical. Not every contract is clearly drafted. Not every contract is well drafted. Not every contract states all the things you need to do as obviously as they should, in my view. So you want to make sure you read through the contract, because you don't want a hidden time bar. You don't want to, an example is the notice provisions that you see in the Australian standards. You want to make sure that you would at least meet the best standard of what's expected around what a notice should be, particularly when it's going to be unclear. And some of these COVID clauses, and again, they swing both ways. We've seen some throwing all the risk around COVID and any eventuality under COVID to the contractor. Obviously, Aaron, when you were working in-house, the goal was to try and make sure that was that risk sat with the principal, particularly around cost and time. But understanding what's going to be required in those notices is going to be really, really critical. Shooting through into the next one. Again, we're conscious of time and there's a few questions popping up. So the critical claims we're looking at, the big ones. Let's go time, variations, and payment. Aaron, across to you.
Yeah, so this is probably where your big three are going to sit: your time, variations, and your payment. This is kind of just what most people will be looking at anyway. Looking at your EOTs, looking at your compensable clauses, looking at any provisions around accelerating this contract, looking at your programming and your rights around programming in particular, because sometimes they can be quite flexible, and allow you to continue to progress a job in a certain way as opposed to being physically present on site. So that can be quite a nifty little tool. Switching across to your variations. Anything that you need to get done in order to get a variation approved or get a variation requested or directed, working through those things properly. And some contracts aren't really clear about these things. They can jump around a little bit. Entitlements and rights can sit in, unexpected parts of the contract. So, that's why we always say read the whole thing and get into it. But making sure this legislative change one, which we've foreshadowed before, is important. Does it refer to works with a capital W, or does it refer to your works under the contract? And then following that through, what has to change here? Is your works changing? Is the works under contract changing? Who knows? It's going to be a little bit different. It might be a little bit of both, but your entitlement will vary depending on how that's drafted. And then, your force majeure, to the extent that there's one in there and it wasn't hacked out, like we're all hacking them out for a long time. How does that work? What does it actually mean? What does the definition mean? We've seen some truly terrible definitions of force majeure. We've seen some really, really broad, good ones that try to split a pretty even position between the parties. And then the last thing we've got there is the Security Payments Act, which is going to be, I'd be somewhat surprised if there wasn't an increase in a bit of security and payment activity following out from this, because there's going to be some disagreements, I think, about how far works have gone along, how where people should be or shouldn't be at. So it's just all these parts really do sow some seeds for a bit of dispute. But Michael said right at the start, communication and how this communication is managed is going to be key.
I mean, even looking at payment, we're assuming it comes to an end on the 30th this month, and I really, truly hope that's the case. If it continues, and particularly given claims going at the end of the month, we're going to have broader questions around how the hell do we even assess those claims if people can't get to site. How's a QS from a financier or principal going to get there and actually determine what the real value of the works are? Are people going to use, we've seen a few force majeure clauses where people can choose to suspend all obligations, and that obligation has extended to payment. There's going to be a lot of things that really come into play, and this is where communicating effectively, early and well will hopefully resolve most things, but at least identify where the differences are. And these are the big ones, that the big ticket items, from methodology through to costs, through to who's wearing the brunt of this, really need to be talked about in a sophisticated way early on, and the way that sort of will determine best practice to do that is going to be a contract. I know that makes me sound way too much like the contract lawyer I am, but I still think that's the tool that provides you that framework. So jumping to the next one, I'm conscious we're 35 minutes in and we're getting a lot of questions popping up. So I'm going to shoot through the next couple of slides pretty quickly. And then if you've got any more questions, put them up there. I'm going to work through some of the questions that Hamish has been answering in the background. But if anything else pops up, please let us know. And yeah, we will also let you know what else we're covering over the course of the week. Insurance. This is Aaron's. Aaron's life was as a construction lawyer and an insurance lawyer, so this is his baby. I'm going to throw it straight to him, and we're going to cover this in a lot more detail later in the week.
Yeah, so I think everybody's kind of, insurance has really, taken a fair bit of heat during this COVID time because of the way that the exclusions in policies, particularly business interruption policies, were drafted. What we were previously looking at was, exclusions under the Quarantine Act for quarantinable diseases. The courts have recently, decided that, have determined that that is not an exclusion that can be relied upon by the insurers. So what we say, so that's a little bit off topic, but what we want to really do here is check your policies, see if you've got any cover. Now, like I said, it is likely to be under a business interruption policy, but check anything that covers first party loss as opposed to a third party loss policy. This is not, a claim coming from a third party. This is a first party loss that's going to suffer because of the orders that have come up. Next thing, it makes sense, but go and collect the evidence to your claims, get a hold of your accountants and the people who you work with, in business partners, to make sure that you can get the evidence that is going to be required to show what type of loss you've suffered. So policies are going to generally give you an idea about what evidence you're going to need. So have a read through them, and like I say, always read the policy, read the clause, but and read the whole thing with any endorsements. So when you're looking at your policies, but go through and collect this evidence. It's going to be mostly financial, but include other things relevant to the loss that you're suffering based on your circumstances. So, pieces of correspondence that you might think might be relevant, keep them in a folder, get them somewhere. Sorry, can we jump back a few then?
Yeah, sorry, let's just move in.
And then, speak with your broker. Your broker's there to help you and act with you in all this situation. They'll help you determine coverage and lodge your claim and collect your evidence and give you advice, invaluable advice in getting this claim on. And then if it is denied, it's important to seek legal advice about this relatively quickly. As I mentioned before, the test cases under COVID-19 have found in favour of insureds. There's another test case which is scheduled for hearing in September this year, with the judgment probably expected to be in October. So to the extent that insurers are dealing with claims, and some of them aren't, some of them are really just putting them on pause until after this second test case is run. You'd want to get them. I think you'd want to get them in and on as soon as possible. And that means if there's any declinatures or any issues with claims coverage, you'd want to get those issues raised kind of straight away and try and get them resolved. Not only because of who knows what's going to happen. High Court has chucked out the first challenge, but who knows how things are going to go further on, because as with contracts, there's a variety of different wordings and exclusions out there. We know how it's going to be dealt with in relation to the change in the Quarantine Act and the Biosecurity Act, but different clauses are going to have different wording. So it's really important to, I think, deal with these in a proactive manner and not just sit on them for a couple of months. And if things change, maybe you'll kick yourself a little bit later, go, well, I wish I had dealt with that a bit earlier. So moving quickly on it where you can would be great.
Yeah. The one I wanted to ask, Aaron, and we haven't talked about this yet, so I'm just throwing things at you as well. What's the practice going to be to make sure that you can maintain your best coverage for the contract works? I mean, if you're having to leave, you've got some rights under this legislation to go in and secure your site, but what should contractors and principals as well be doing to make sure that they can, if something happens to the site over this next 2-week window, what should they have done to try and protect themselves?
Yeah, so your contract works policy normally covers physical loss or damage. So if you're not on site, you've got to make sure that you've done everything you can to make sure the site's secure. You don't want to be in a situation where unfortunately the locks have been left off or something silly like that's happened. So while you've got the time, go sure and make sure that all that's in place. It's going to be an interesting situation. If that did arise, it would be interesting to see how that was dealt with in the absence of any people being on site. Again, check the policy, check the clauses, read the whole thing and see how it would be dealt with. But it's difficult to put it kind of off the top of the head way that would be kind of construed. I guess one thing maybe to mention would be that it's unlikely that would be a widespread issue. So perhaps insurers would deal with it on a different way to the way business interruption claims are being dealt with, which, because of the massive scale and quantum that's likely to be suffered by the industry, obviously there's a really hard line being taken. Who knows if that's likely to be the case with other policies, which you probably one would assume that they might be dealt with slightly differently.
Thanks, Aaron. So jumping into the questions, and if you do have anything, let us know. These are some of the ones that were thrown to us yesterday. Not all of them, but we've tried to capture some of the ones that go to the heart of some of the questions being raised. I'm going to use this as an opportunity as well to really say, lean on your industry bodies. We're members of the MBA, HIA, and really big supporters of the Civil Contractors Federation in particular. The material that's being put out by those industry bodies and it is excellent. I'm getting the mail outs as they come through. I'm looking at them. I'm reading the legislation. We're in it pretty deeply, and they're putting out really good quality stuff. The HIA, for example, put out an excellent checklist yesterday. The material being put out by the CCF, including around managing your workforce, is phenomenal, and managing IR issues is really phenomenal. And the lobbying that they're doing in the background and some of the information they're getting directly from government is really good as well. So to the extent you have an industry body and you're a member of it, please be making sure that the right people are receiving that information and be passing through questions to them. I know they're all really busy, but they are getting back to people. So we're not the source of all knowledge, but we're certainly really impressed with what the industry bodies we're dealing with are showing. So one of the questions we've had a run of is, we're not based in Sydney or the related regions. What does this mean for us? You still need to be really thinking about a lot of the material, a lot of potentially aspects of your workforce, things that have been coming out or linked to Sydney may give you rise to be making a claim under your contract. So really turn your mind to, and hopefully you did a bit earlier when the ring got put around the Sydney and the greater Sydney region, and we throw in Wollongong and Blue Mountains and Central Coast into that as well. But you really need to be thinking about, well, what is that going to mean for our projects, and making sure you get those claims in, particularly where there's COVID clauses, because there's there may very well be entitlements there. If you can't get materials, if you can't get trades, if you can't get supply, if you can't get the requisite workforce, now's the time to be putting those claims in. Aaron, did you have any more thoughts around that one?
No, I think that's right. And I think there was a piece in one of the news articles yesterday about the concern about people travelling from different areas to do that. I think that's not a silly thing to be concerned about, and something that I think people should keep their eyes open for as well.
Yeah. Quarrying related material manufacture, in or out? That was a really good question. We did a bit of a deep dive onto that one yesterday. I mean, again, not giving legal advice by any stretch at this stage, but I think you have to work within the ambit of what the order looks like at this moment in time. And they've been very particular around what a construction site is. They've been very particular around defining, as it affects residential premises. And if you don't sit within that definition, I think the assumption has to be that you can continue. Aaron, did you reach a different conclusion? You can tell we haven't talked about this in great detail, so we're doing it live on air, I guess.
No, I agree with that, and I think like I mentioned at the start, there's not been a lot of no one's had a great deal of time to consider these or get their brain around them. So I think where you can form a reasonable view, such as like that, I think that's a reasonable way to proceed forward.
Yeah, and get advice. I suppose we're not saying we're giving advice by any stretch, but some of the people we're talking to have sophisticated commercial and legal teams, or have good advisors, or if you want particular advice from us, please reach out. But an example, I'm just trying to think of a live example. Last year when they were shutting down the borders and people were having to work out whether their workforce could or couldn't travel, and whether it was essential construction work or not, getting advice to even being able to show authorities, or for your workers to be able to show, this is why I'm doing X and why we say it sits outside of what the orders are, is really useful and empowering for your team. People that are on the ground may not have the sophistication to explain, if they're pulled over by the police, why they're able to operate a quarry site. But if you've formed a view that they're entitled to because it sits outside of what that order says, then give them the tools to do it. Don't just tell them to turn up to work without giving them any substance. So I think that goes back to that communication piece. Giving the tools to your team to effectively do things really important. Aaron, I'm going to throw a really curly one to you next. What would be urgent and non-urgent work? How do you determine if it's necessary? And this feeds straight into some of the Q&A, so I'm not going to go through all the examples, but things from a working toilet to having roofs off, to there's a few, there's quite a few other ones getting thrown out here at the moment. I haven't worked through all of them. I know Aaron's answering, I know Hamish is answering a lot directly, but good examples, no functioning plumbing, no roof off. How would you work out if that's urgent or non-urgent?
Yeah, like, well, it's such a difficult question. I think, I've got, a lot of my family members are in trades and a lot of them aren't working this week, but certain jobs that they are doing are in that kind of urgent category. And it's, I haven't had to answer too many of these questions yet. Thankfully, Hamish has been doing all that. But look, if you got no roof, maybe that is something that would be considered urgent. If you just simply would like to have a better roof, then perhaps that's not something that would be considered urgent. So I think it's going to be definitely on a case-by-case basis, and using a little bit of that common sense approach. Really ask yourself, and being honest, could this wait 2 weeks? And if it could, it's probably not urgent.
Yeah. I guess the next one, so I'll jump in here, and this has come through from a few, particularly residential builders. What if you've reached PC and no further construction work is required? Do the rules prevent you from settling the property? And I guess, as it stands at the moment, that doesn't seem to be excluded. From what I had a big read through last night, because I got that question from more than one person, which is great to see projects are coming to an end. So, tick that box. But if it's not construction work, so potentially, yes, you can go ahead and settle the property. Obviously, you can't be showing things, and there's some other elements around it, but that doesn't necessarily prevent you from completing the logistical exercise of handover on some of those PC projects. Did you reach a different view at all, Aaron? Again, we haven't talked through these, so apologies. We're having the debate live on air.
No, I think I agree, because the order just really talks about work being undertaken, so that's very, very broad. And then what it does is it carves out certain things that are allowed to be carried on, and so if you're not carrying out work, that's really it. But then I guess the kind of difficulties you're going to get, the practical difficulties are you can't go onto site anyway. So as long as you can do these things in a way that you're not going to go onto site, and that you're still complying with the rest of the orders, which I don't know if that's actually physically possible in a lot of circumstances. So you'd have to think about really navigating that, navigating not only just the cannot carry out work element, but the stay at home components of the orders and the reasonable excuses for leaving too. So it's not just we're not doing work, therefore we can do it. It's we're not doing work, but can we also tick all the other boxes that are required under the order? So it's really, really tricky from a practical standpoint, which is how I think this thing should be approached.
Yeah, look, it is, and I think it may be, this is where using the contractors as your tool again. I don't think it should be used as a weapon unnecessarily, if I can frame it that way. I'm certain there's moments where that's important, but if you're a project home builder working under a version of the HIA or MBA standard form contract, you probably can do most of that handover post PC without, in the framework of these orders. Where things might need to be extended out is it might have to be agreeing that it's not. Often you have 10 business days to raise any defects. Obviously, that's not going to be feasible now. It might be given, agreeing on extensions to allow those things to practically work. And so that's going to be a bit of a case-by-case approach, but I certainly think it's achievable. I'm going to shoot across onto our next slide, which is obviously the question slide. I'm going to, Hamish has been answering a bunch of them in the background. I'm going to work through a few. I'm conscious we've only got 10 minutes left, so I'm going to do this for about 5 minutes. We will circulate, we will try and put together sorry, Hamish isn't the only one answering it. Thanks to Josh Mills, one of our other lawyers who's jumped on to help Hamish with this too. We will try and circulate a bit of a Q&A covering off on these. So if people can reach out to us and let us know if they're not registered for our newsletter already, if they want a copy, we can do so. So jumping through a few questions. One's any advice regarding unproductive staff on annual leave during the shutdown? there's going to be stand down rights. There's going to be a whole bunch of things that roll off the back of it. We're dealing with that tomorrow, holistically. Employment is really an hour on its own because there's a lot of things that are going to impact on staff. And I think they'll come more to the fore tomorrow once you've got on top of what you can do with sites. So I'm not saying that to opt out of that, but just saying that's something we'll cover in more detail tomorrow. Regarding the rumours that things are going to change in 10 minutes' time, I'm not working within that context. We're working in what we've got. So I'm just working through these questions now. So apologies. We're reading it.
It's great. There's so many questions, and every time I've been flicking through them as well. They're none of them are straightforward. So, and we've been dealing with this order, over the weekend and trying to get a handle on it. So it really does emphasise that we've got 100 odd people on this, and
yeah. So I'll jump through. Yeah. So jumping through a couple, a good one is I'm a builder and I'm currently building my house. Can I work on site on my own? The answer, in our view, in the current orders is a clear no. That would fit within the residential category pretty comfortably. So you can't really be doing that. Again, public health orders and legislation are designed to capture most things. And I know some things might be wiped out that don't comfortably sit within that, but we can only work within the way things are framed.
That is an interesting one though about working on your own home, because some of the exclusion in 4A is about allowing other people to visit your home and do things. So you couldn't do any of that. So it really depends on, I think, again, it seems, obviously the first answer probably not. And then you look at it and then, well, is someone visiting? And so it's important to really work through those kind of, those sections too. It's, because I was looking at that one as well while we were doing this, and it's I find that one, that's quite a tricky one that really kind of stumped me a little.
Yeah, so we'll try and cover some of these in a bit more detail. We might shoot these across as a Q&A because there's actually some really quality questions coming through here. I'm conscious we're about to move into a press conference soon, and people will want to be watching that probably more than they want to be listening to us. I guess what we're going to try and cover over the course of the rest of the week, because there is a lot of material to cover, and we're doing this because we do believe that we can add some value for people, and if we can help by just running these things for an hour at a time, and they do add some value to you and your business, that's what we're here for. At Morrissey Law, we're really about building better relationships, and we want to be able to help people, however that may look. So we'll share on LinkedIn and over our email the next run of seminars later today, but the first one will be drafting claims successfully. So it flows on straight from the context of what we've been talking about here. That'll likely be at 10 a.m. tomorrow morning, and that will be led by Claire Brennan, one of our senior associates. So just talking through how to put these claims, we've been emphasising you do together, putting those claims together in a practical perspective. Tomorrow afternoon, we're aiming to cover employment law issues, and a number of questions have come around that. So obviously coming all the changes, what your options are, what the risks are, including some of the provisions around working from home. The language around that has been changed quite dramatically and does expose some pretty significant penalties to employers if they require people to turn up to the office when they shouldn't have to. And we'll talk through something that we covered in a fair bit of detail last year, less in construction, more in other industries, but what stand down law looks like. Can you stand down a team, and what that means and what the implications are. Later in the week, we're going to cover payment essentials, and that's hopefully going to cap off on a few questions here. For example, you're 70% through a certain piece of work, is that claimable or not? So we're going to talk through probably the critical elements around payment clauses, and we are going to talk through the security of payment regime in a bit of detail. It's a really important tool, and particularly where there might be disputes coming up around payment, to try and resolve things in a faster way. We're pretty proud supporters of security of payment a lot of the time. I know not every lawyer is, but we do think that it can add a lot of value in the right circumstances. Later in the week, we're giving Aaron back to you to cover all things insurance and a deep dive around what he was covering today. And the last few things we're hoping to cover this week are really talking around what your duties as directors are, or as business owners, because you don't want to have exposure. You don't want to have exposure around what you've been doing, particularly where cash flow is becoming a problem. You might be I appreciate just how big some of these claims are going to be and how some businesses do need to get paid each month to be able to continue moving. So what your obligations as directors are, and then managing insolvency risk. And this is going to be include around talking around what the safe harbour provisions are. I'm conscious it's already 5 to 11. Excuse me. Aaron, was there anything else you wanted to touch on?
No, that's all. I think if you have like anything that, if we haven't answered any of your questions and you're not sure and you want an answer, flick through an email or something. We'll try and get something really bespoke back as soon as we can. It's super challenging, and like I said, we've been kind of nerding out over this all weekend, and it's still clear as mud. So
yeah, I mean, just answering one of the last questions that's come through to close it out. If you're based outside of Sydney and you're trying to claim EOTs or delays or variation costs because you can't get the trades or maturities out of Sydney, you're really going to have to deep dive into your contract. For example, I'd be pretty comfortable claiming that under the HIA, MBA, and potentially the ABIC ones, even some versions of the the Australian Standard Suite, but other ones where it's bespoke and amended, it might be a bit more difficult or a few more paths to go through. We're going to log off. We'll leave this running just for another probably 5 minutes or so, just to allow Hamish and Josh some time to answer those questions in writing that they're currently answering. Please message Aaron or myself or our team at Morrissey Law if you want more information, or if there's something we haven't covered, or if there's things you want to cover later in the week. From our perspective, we're here to try and give those information and resources. Obviously, if we can help in other ways, we will. But, our priority is trying to give meaningful information to you to help this week. So thank you to everyone that's taken the time to log in. We hope you and your families and your team are all safe, well and secure. And, our thoughts are with you during this really stressful and difficult time and confusing time. We'll be doing updates later in the day and checklists that will circulate across our mail outs and on social media to the extent we can. But if you do want that, please just reach out and we'll try and aim to get that through to you. We'll also be sharing to people whose email addresses we do have access to copies of the slides and materials. And if you want to record it of this, please let us know. So thank you very much. We're about to disappear, but we'll spend 5 minutes just answering the questions that are still open. Thank you.
You're